At first glance, the hearing appears routine, but the charges being read carry serious, life-changing consequences. The defendant faces multiple felony counts, and the decisions made in the next few minutes could shape his entire future. Whether he ends up spending decades behind bars or accept a deal that significantly reduces his sentence may be determined right here in this courtroom.
Okay. All right, so are you Kendrick O'Veal?
Yes, ma'am.
You are charged with evading arrest or detention with previous conviction, and that's from August 31st of 2025. That shows that you were previously convicted of evading arrest or detention July 22nd of 2011. So that's what makes it a state jail felony. Then the indictment further alleges you were convicted of attempted robbery, a third-degree felony, March 28th of 2013. And after that was final, you were convicted of assault, a third-degree felony.
This is a moment where the legal stakes begin to rise. Those prior convictions aren't just part of the defendant's history. They significantly increase the possible punishment he could face. In criminal law, this is known as sentence enhancement. The justice system often treats repeat offenders more severely, meaning earlier crimes can turn what might have been a lighter sentence into a far harsher penalty.
September 11th of 2019. And so what that means in that case is that if you go to trial and you're found guilty, and those prior convictions are true, the range of punishment would be enhanced to a second-degree felony, which is between 2 years and up to 20 years. Do you understand?
Yeah.
And then, in cause number 25 DCCR 1777, you're charged with unlawful possession of a firearm by felon. And that is...
This charge carries serious weight. In many states, once a person is convicted of a felony, it becomes illegal for them to possess a firearm. Because of that, the central issue for a jury, if the case goes to trial, will be straightforward but crucial. They will need to determine whether the defendant knowingly possessed a firearm on or around August 31st of 2025.
From August 31st of 2025. That indictment alleges one prior felony conviction, the one from 2019, but the state can file, and I anticipate they would file, a notice of enhancement because that 2013 was left off of that indictment. And so what that means in that case is if you're found guilty and if those prior convictions are true, you would be considered a habitual offender with a minimum punishment of 25 years in prison, up to 99 years or the rest of your life. Do you understand? And then finally...
Did you catch that? Being classified as a habitual offender changes the entire situation. The minimum possible sentence immediately rises to 25 years, and it can extend all the way to life in prison. At this stage, the courtroom isn't simply reviewing charges anymore. It's confronting the very real possibility that the defendant could spend the remainder of his life behind bars.
Finally, in cause number 25 DCCR 1778, once we get all these done. You're charged with a third-degree felony offense of deadly conduct discharging a firearm from that same date of August 31st of 2025. It does allege those two prior felony convictions. Again, what that means, if you're found guilty and if those prior convictions are true, you would be considered a habitual offender in that case also, with a minimum punishment of 25 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
In all of those cases I have here on this tablet,
This is a moment that often shapes the course of a case, the plea deal. Prosecutors commonly offer a reduced sentence to avoid the time and cost of a full trial. Accepting the deal requires admitting guilt, but rejecting it means taking a serious risk and leaving the final decision in the hands of a jury.
A plea bargain rejection in each case that you've signed with Mr. Parker that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty in your cases, to go on, probably it looks like counts 1 and 2 for a 15-year term instead of that habitual. And so in 2 of the cases a 15-year term, and then in
it's 15 on all, concurrent on all of them, Judge. Yeah, because it's state jail is it.
Oh, I opened the wrong one. Sorry. Hold on, y'all don't want me to do that. That's a 30.
Oh, that's my next one.
Sorry. Okay. So 15 years in all three cases that would run concurrently, which means together at the same time. Do you understand what the state has offered you?
Yeah.
And so you have every right to reject that offer and have all three of your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to enter a plea of guilty in your cases. And do you understand all of that?
Yeah.
And do you want to reject those offers and have your cases set for trial? All right, we'll get that done. I do want to, is there any reason to believe that these offers would change?
Not at all, Judge.
So, Mr. Oville, I want to make sure you understand that after today, unless there is new evidence that is discovered by either your attorney or the state's attorney, I will not accept these plea agreements again. Once it's on the trial docket, it either goes to trial, you can plea open to the court, or to some different amount or negotiated punishment. Do you understand? Okay, so I will get your cases set for trial. Mr. Oville, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and I can appoint a new attorney today who could begin preparation for trial a little quicker. Is that okay with you? Okay, so Mr. Parker, you're released. Mr. Oville, we will appoint someone today. They should be out to see you very soon to begin preparation for trial.
Thank you.